Good evening, folks. This is Tarek Rawlings. I'm a planner with Deschutes County Community Development Department. We're just waiting on the hearings officer to arrive, and so we'll be with you shortly. We'll have kind of the proceedings up and going once we have the hearings officer in the room. So thanks for your patience. We'll be up hopefully very soon. Hello again, folks. Just a quick update. We're going to be about 10 more minutes until the hearings officer arrives here. So thanks again for your patience. And so we'll try to pick things up around 6:20 if everything's all in place at that time. So thanks again for your patience.
Good evening. My name is Stephanie Marshall. I am the Deschutes County Land Use Hearings Officer assigned to this matter today, Tuesday, February, woo, see? Tuesday, April 26, 2022. It's 6:15 p.m., and I appreciate everyone who's been online waiting for the hearing to begin. This is a quasi-judicial hearing, and the county file numbers are 247-21-000881 PA and 247-21-000882-ZC. In this application, the applicant has requested approval of a comprehensive plan amendment to change the comprehensive plan designation of the subject properties from agricultural to rural industrial. The applicant also requests approval of a corresponding zone change to rezone the properties from exclusive farm use, EFU, to rural industrial, RI. The hearings officer takes notice of the record below and includes that record as part of the record before us. The applicants have the burden of proving that they are entitled to the proposal sought. The standards applicable to the application before me are noted in the staff report, which is available on the table near the entry door, right over there to my left, and also online. Testimony and evidence at this hearing must be directed toward the approval criteria, as well as toward any other criteria in the comprehensive land plan of the county or land use regulations which any person believes apply to this decision. Failure on the part of any person to raise an issue with sufficient specificity to afford the hearings officer or parties to this proceeding an opportunity to respond to the issue precludes appeal to the Land Use Board of Appeals on that issue. Additionally, failure of the applicant to raise constitutional or other issues relating to the approval with sufficient specificity to allow the hearings officer to respond to the issue precludes an action for damages in circuit court. Evidence to be reviewed by the hearings officer. The hearings officer's decision on this application will be based on the record before the hearings officer, the staff report, and the testimony and evidence presented at this hearing. There may be a request to leave the record open at the conclusion of the hearing, and if so, I will address that at that time, and any items submitted during that open record period in a timely manner will also be considered as part of the record. The hearing will be conducted in the following order. 1, staff will give a report. 2, the applicant will then have an opportunity to offer testimony and evidence. 3, proponents of the proposal, then the opponents, and then those that are neutral will be given a chance to testify and present evidence. The applicants will then be allowed to present rebuttal testimony, but may not present new evidence. At the hearings officer's discretion, if the applicants presented new evidence on rebuttal, opponents may be recognized for rebuttal presentation. At the conclusion of this hearing, staff will be afforded an opportunity to make any closing statements. The hearings officer may limit the time period for presentations, and I will state for the record that I typically do not do that, but I encourage anyone that is presenting testimony this evening, first, please do not read letters that you have submitted into the record, because I will be reviewing those letters and emails myself. And second, please try to limit duplicative testimony. If anyone wishes to ask a question of a witness, the question may be directed to the hearings officer during that person's testimony. Or if the person has already testified, then after all other witnesses have testified, but before the applicant's rebuttal. The hearings officer is free to decide whether or not to ask such questions of the witness. Continuances. The grant of a continuance or record extension shall be at my discretion, the discretion of the hearings officer. If the hearings officer grants a continuance, the hearing shall be continued to a date certain. If, at the conclusion of the hearings officer leaves the record open for additional written evidence or testimony, the record shall be left open to a date certain for submittal of new written evidence or testimony, and at least 7 days for response to the evidence received while the record was held open. Written evidence or testimony submitted during the period the record is held open shall be limited to evidence or testimony that rebuts previously submitted evidence or testimony. If the hearing is continued or the record left open, the applicant shall also be allowed a period to a date certain after the record is closed to all other parties to submit final written arguments, but no new evidence in support of the application. Now I'm going to make a statement regarding pre-hearing contacts biases, or conflicts of interest. I have had no ex parte contact outside of the hearing this evening concerning the application before me. I have received a staff report, and I have coordinated with staff to schedule the hearing this evening, but I have not reviewed any materials other than the staff report and have not gone to the property to view the property. So I have had no ex parte contacts with anyone interested in the outcome of this application. And as I just stated, I've not made any prior hearing observations. I believe that I can conduct this hearing in an unbiased manner, and I have no conflicts of interest to declare. I have no interest in the applicant or the applicant's proposal. So at this time, I will ask if anybody wishes to challenge me as hearings officer based on ex parte contacts, biases, or conflicts of interest. And I'll wait a moment to allow anyone time to respond. Okay. All right. Well, at this time, I will turn it over to staff to go over participation via Zoom, and then we will go into the staff report. Thank you.
I'm just going to share my screen really quickly, and everyone can see that. All right. Good evening. For the record, my name is Tarek Rawlings, and I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is a request for a plan amendment to change the subject property's comprehensive plan designation from agricultural to rural industrial, and a corresponding zone change to change the subject property's zoning designation from exclusive farm use to rural industrial. I'll begin the hearing by explaining how the hearing will be conducted and how members of the public can testify. And then I'll turn the hearing over to Hearings Officer Marshall, and she can give hearing instructions. She gave some preliminary statements there, but there'll be potentially some more information then. I'll then follow with my oral staff report. The applicant will then make its presentation, and then the public will be invited to testify. Then the applicant will be given an opportunity to present any rebuttal testimony. And lastly, staff will be afforded an opportunity to make any closing comments. Tonight's hearing will have a hybrid format, allowing both in-person and remote participation. Should the county's internet connection be interrupted, we will attempt to get back online as soon as possible. If this happens, please give us a couple of minutes to reactivate the public hearing before you attempt to link or call back in. If your own connection gets interrupted, please attempt to join back using the same link or phone number you used initially. In Zoom, there are two categories of participants: attendees and panelists. As an attendee, your video will not be active, and the county's producer will control your microphone. As a panelist, your microphone and video will be active for everyone to hear and see you. This is an important distinction because anyone wishing to testify via Zoom will be promoted to a panelist so that the audio and video can be recorded. For everyone joining us in person, there's one in the room, looks like. If you would like to testify tonight, make sure you've added your name and mailing address to the sign-in sheet at the front of the room. Because this list will be used to call up each person for their testimony. For those joining us via Zoom using a computer, once you're promoted to a panelist, you'll see a button for your microphone in the bottom left-hand corner of your screen. If you press this button, you'll mute your microphone. I point this out because during your testimony, you may want to confer with your legal counsel or your client. You can use this button to mute your microphone so that your conversation is not recorded. To the right of the microphone button is one for one for video. By pressing on this button, you can black out your video. Again, during your testimony, you may want to confer with your legal counsel or your client, and using the video button will allow you to black out your video if needed. And lastly, in the center of your screen, you'll see a raise hand button. In a few moments, I'll ask for anyone joining us via Zoom to press the raise hand button if you would like to testify. For those joining us via Zoom that have called in by phone, once you are promoted to a panelist, if you need to mute your microphone, you will need to dial *6. You'll be notified your microphone is now muted, and to unmute yourself, you will need to dial *6 again. As I mentioned to the other Zoom participants, in a few moments, I'll ask everyone participating remotely to use the raise hand feature if you want to testify. To do this on your phone, please dial *9. You'll be notified when your hand is raised. At this time, for everyone joining us via Zoom, if you wish to testify, please press the raise hand button or dial *9. One at a time, I'm going to ask our producer to elevate each person raising their hand to a panelist. Once you're elevated to a panelist, I'll ask you for your name, mailing address, and whether you intend to testify in support, neutral, or in opposition to the applicant's proposal. Please keep your hand raised until I get your name and information. And let's see here. Okay. And Ken, are you able to, or I will, yeah, is Ken elevated at this time?
Yeah, he is.
Excellent.
Thanks a second. He's on.
And Ken, you're on. Ken's the representative of the applicant. I assume you'll be testifying in support, but let me know if I have that incorrect.
You are good, sir. Thank you so much. Ken Katzroff for the record. 1420 Fifth Avenue, Suite 3400, Seattle, Washington, 98101.
Very good. All right, and then the next person joining us via Zoom,
I don't see any other hands raised.
no other hands raised. And then are there any phone testimony? Any?
I have another hand raised, Scott Ferguson, bringing him over.
Okay. And hi there, Scott. I believe Scott's the traffic engineer for the applicant, but please let us know if you be testifying in support this evening or otherwise.
He's unmuted.
And yeah, it looks like you're unmuted, Scott. I just don't think we can hear you. You might have to check your audio settings near the microphone button. And we'll give Scott a minute here, but just based on a couple of messages I've gotten with him today, I would assume Scott's going to testify in support as part of the applicant's team, but we'll be sure to clarify that before moving to his testimony.
Do you want me to bring over the next?
Yeah, I think just for interest of time, we could bring up the next.
I've got Scott and Rhonda bringing them over.
Okay. And hi there, Scott and Rhonda. It looks like you're up. We just, if you wouldn't mind unmuting and letting us know your name and mailing address and whether you intend to testify in support or neutral or opposition.
Oh, hi, this is Scott Ferguson. I forgot I don't have a mic on this computer I'm using.
Oh, okay, this is Scott Ferguson. Hi there.
The cell phone works fine for that.
Okay. And Scott, what's a good mailing address for you?
G Scott, so GSCOTT at traffic-team.us.
Sure. And maybe a good mailing address for you, Scott?
PO Box 1994, Redmond, Oregon 97756.
Right. And will you be testifying in support this evening?
Yes, as a representative for the applicant.
Very good. All right. Thank you very much, Scott.
I don't see any other hands raised.
And no, it doesn't look like there are any other hands raised. And so with that, I'll just go quickly over kind of repeating a little bit of this, but this is the order of testimony this evening for the hearings procedure. The first will be the applicant. Second will be anyone in support of the applicant's request, beginning first with anyone in support that's in person, followed by anyone remotely that would be a participant supportive of the applicant's request. That'll be followed by anyone neutral of the applicant's request. Anyone in person will lead, and then anyone remote that's neutral. And then next will be anyone in opposition to the applicant's request. In-person testimony will be called up first, and then remote participants will be called up next. And lastly, the applicant will have an opportunity for rebuttal testimony. With respect to oral testimony, the hearings officer and staff are responsible for ensuring a respectful and orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. In addition to oral testimony, you may want to submit written testimony at the hearing. If you're in person, please submit your written testimony to me prior to beginning your testimony. If you are participating via Zoom, you can submit your written testimony via email. My email address is on the screen here. Please keep in mind that if your submittal is more than 20 pages in length, includes any color figures, or includes documents which should be printed larger than 8.5 by 11-inch size, then you'll need to submit the testimony both electronically and as a hard copy. Are there any objections to the format of the hearing using Zoom and telephone? If yes, please use the raised hand function now.
Don't see any hands.
And seeing none, I will return the public hearing back to Hearings Officer Marshall.
Okay, thank you very much, Mr. Rollins. We will go ahead and start the hearing, opening up, as we've mentioned several times, with the staff report. So I will hear from Mr. Rollins at this time.
Thank you very much, and I'll share my screen again here. You can see there. All right, so good evening. Again, for the record, my name is Tarek Rawlings. I'm an associate planner with the Community Development Department. Before you is a proposal for a plan amendment zone change. The location of the property, and again, this is a plan amendment portion is for a comprehensive plan designation change from agricultural to rural industrial, and then the zone changes from exclusive farm use zoning to the rural industrial zone. That's the request this evening. The location involves 3 different tax lots. They're a total of 19.12 acres located along Highway 97. The largest of the tax lots, tax lot 301, is 15.06 acres in size. The second largest, tax lot 305, is 3 acres in size, and the third is tax lot 500, which is 1.06 acres in size. The applicant in this, for this plan amendment zone change is LBNW LLC, and they are the owner of 2 of those lots. As we just talked about, this is a plan amendment and zone change, changing the plan amendment, the comprehensive plan designation and the zoning district. There was a traffic study included that goes over traffic impacts related to the proposed changes. There was no Goal 3 exception proposed because there's a soil study submitted and verified by DLCD related to the soil classification and agricultural soils. And then there, with the proposal and with the application is an exception for Goal 14 for urbanization as an alternative argument. The applicant's primary argument does not involve a Goal 14 exception. We've received many public comments in support of the application, some from neighboring property owners, most from elsewhere, and kind of community members. There are not specific criteria that they are supportive of, but they generally fall along the lines of economic opportunities, kind of related to growth in the area, the need for industrial uses, also due to growth, and then improvement of the subject property since the new owners have taken over. That's been pretty consistent themes throughout the supportive comments. The oppositional public comments, one is expressing a need for exceptions to goals 3, 11, 12, and 14, and that this proposal would constitute a potential loss of agricultural land, and that it would also potentially be incompatible with residential properties to the west located in a residential subdivision. And there was also mention of potential pollution associated with future uses on these properties. We've received a few public agency comments, one from Oregon Department of Transportation, basically lining out the applicant on some road approach permit requirements, asking them to kind of coordinate with ODOT on what that new road approach permit might look like, going off of Highway 97 there. Central Oregon Irrigation District has issued a comment essentially just quantifying the amount of water rights and canals and laterals on the property, explaining, similar to ODOT, that they'd like to work with the applicant to either move those water rights around or otherwise kind of handle them if should this be approved or otherwise. And then lastly, our own Deschutes County Senior Transportation Planner, Peter Russell, has weighed in on the traffic study, offered some comments, and there were revisions kind of that came about from that process. So those are the main public agency comments we received throughout the noticing period. And what you'll see in the staff report tonight are kind of these 5 main areas of for key issues here. One is the non-conforming uses on the properties, whether that relates to any kind of irrevocably committed goal exception argument, whether that even plays into goal exception or not, but it's unclear the full extent of the non-conforming uses. The bridge access over the canal appears to be kind of a private bridge access, but you'll see in the staff report that there's questions about sort of the general safety of the bridge should it become a public facility if this were to be approved. Goal 3 compliance is outlined throughout the staff report, asking the hearings officer for clarification on various criteria throughout Goal 3. And then kind of as a very pretty major theme throughout this staff report, there's an attempt to really characterize Goal 14 exception within case law, local case law, and ASETI, and several other cases that I'm sure you're very intimately familiar with. And so that was, we are also looking to the hearings officer for kind of the most recent take on some of that case law framework. And then lastly, there's the transportation study potential for, there's discussion of a trip cap essentially has become kind of one of the more specific elements of that transportation study, traffic study discussion. So those 5 key issue areas are really what I've tried to draw your attention to, Hearings Officer Marshall. There have been a couple last-minute record additions. We've had 18 supportive public comments that came in about a week just before this public hearing, so lots more support. There was a kind of another formal agency comment from ODOT, which I just referenced on the last slide, asking about a road approach permit with the applicant. And then just this evening, which you do have a copy of the email from 1,000 Friends of Oregon, that was an oppositional comment that I just received right at about 5 p.m. And then I just was handed a larger hard copy of Central Oregon Land Watch's kind of supplemental information that is added on to their initial public comment, which was in opposition to the proposal here. So some next steps are that you could continue the hearing to a date and time certain, close the hearing, and leave the written record open to a date and time certain, or close the oral and written record. And with that, I'm available for any questions you might have, Hearings Officer Marshall.
Okay, thank you, Mr. Rawlings, and I also want to thank you for a very thorough staff report. Obviously, it was distracting enough to me to cause me to be a few minutes late. And again, I appreciate everyone waiting and being patient. I don't have any questions at this time. I may, at the conclusion of the applicant's testimony and after hearing from people testifying in support or opposition or neutral to the application. So appreciate the time. Thank you. Okay, at this time, I would like to hear from the applicant, and I believe that would be 2 people, separate people online. Perhaps Mr. Katsarov. No, Mr. Katsarov first, please. Thank you.
Looks like I'm in the hot seat again.
Yes.
For the record, Ken Katzeroff, 1420 Fifth Avenue, Suite 3400, Seattle, Washington, 98101. I'm an attorney at Schwab, Williamson & Wyatt here on behalf of the applicant. I am going to, as I say before most of my public hearings, try to keep this brief, except this time I really do mean it. And that's because we are going to ask this hearings officer to hold this hearing. However, we would like to request that we have an extended open record period in order to address a couple of comments that have come in, as well as some other issues. I'm going to get into that in a second. But our proposal at this point in time is that we open the record for 28 days. but with the caveat that we may seek an additional extension of the open record period. We think that based upon the level of comments, both in support and the few in opposition or with questions, my dog is making noise, I apologize, that it may just be worth having additional public process and keeping the record open if necessary. So anyway, I'll give my presentation and then we can come back to that if you would like. I have to figure out how to make sure this works correctly. I assume you can see my screen. Is that correct?
Yes.
All right. I don't need to go over this. We've already done that extensively. Here's a little bit of background on the property. Again, there's 3 properties. There's 2 smaller ones and 1 larger one. Currently, tax lots 305 and 500 are developed as structures and really have been a historic rural use for diesel shops and equipment rentals and things of that nature. 301, which is the larger of the tax lots, has a manufactured dwelling on it. The subject properties have had historic non-conforming use on it. However, I will note that at this particular point in time, those uses were abandoned. So I'm going to go ahead and acknowledge that because it's true. But it is relevant to what we're asking. We are not seeking an exception on the basis of having non-conforming use, merely using that evidence to show that these properties really have never been used in another way. So I'm going to move forward. This is an aerial photo of the property as it were in 2018. As you can see, the structures where they're developed, as well as that bridge across the COID canal. Got a couple more photos here just to show you. It's pretty much always been in the same with a rural use, and at this point in time has been cleaned up quite a bit. 2000, 1994. Okay, now we're going to get into kind of the meat of this as I go quickly through it. Staff highlighted the main issues, we think, Goal 3, Goal 12, and Goal 14. As this hearings officer is well aware, Goal 3 tends to be one of the things we're fighting about in Deschutes County right now, and this is the classification of ag land. And we have provided a soil study that shows that we do not meet the classification of agricultural soils, and I'm not really going to address this point anymore today. So I'll leave it there. We have a soil study in the record that supports the rezone and the Goal 3 analysis that we've provided, and I'm going to leave it there. Goal 12, this is one of the main reasons why we are looking at asking for additional time in the open record submittal, and that's in order to deal with some transportation concerns. We have some ongoing discussions with ODOT as well as the county transportation planner, and would really like to robustly analyze this and get back to the hearings officer and submit additional testimony on this matter. And I'm hoping we can sew that up in short order, but rather than continue the hearing, we would certainly rather just have an extended open record period. Okay. The last thing I really want to talk about is Goal 14. This is the one that is, I wouldn't really say in flux. We have asked for kind of a belt and suspenders approach to this hearing, this application, which is to say that we do not believe that an exception to Goal 14 is necessary. That has been confirmed in other case law, such as the Assetti case, because the uses allowed in the rural RI zone are rural uses. It's an acknowledged zoning designation, and that's it. And to be clear here, kind of in a quick response to the 1,000 Friends letter that has been submitted today, the uses that are currently on the property, were on the property and as a historic use, are uses that are allowed in the rural industrial zone. And again, that's an acknowledged zoning designation, so it is by definition rural, which is why no exception is necessary. The last thing I want to talk about really quick is that bridge. I'm not sure I really understand staff's comments of the bridge over the COID canal. There isn't a way that I am aware of that would become a public facility. Deschutes County is not requesting that we dedicate any road or right of way or anything of that nature. And in fact, in any application that I have or have worked on, Deschutes County is not accepting additional dedications either. So I'm not quite sure how that could become a public facility. That said, we are aware that in the event we want to replace that bridge or otherwise, we're going to need to get a permit or an agreement with COID. And we've already had discussions with them about it, but that's not really relevant in my mind to the question of the rezone. So I'm going to leave it there unless you have questions for me. We are not planning to have Mr. Ferguson or our soils expert testify unless there's something in rebuttal that we need to hit today, given that we're proposing a robust open record period. So I just want to be mindful of your time.
Okay, I appreciate it. Thank you. I don't have any
you.
questions at this time, but we will see as the evening proceeds. All right, is there anyone else that wishes to testify in support of the application, either in the room or online? Okay. Scott Ferguson? Mr. Katsaroff, is Scott going to be, it sounds like you just stated that he's available for rebuttal, but he's not presenting at this time. Okay.
Yes, hearings officer. Thank
Great.
you.
Okay, thank you. Okay, all right. Anyone wishing to testify in opposition? Yes.
Should I come up here?
Yeah, go for it.
Yeah, please do.
Good evening, Hearings Officer Marshall. For the record, my name is Rory Isbell. I'm a staff attorney for Central Oregon Land Watch. Our address is 2843 Northwest Lolo Drive, Suite 200, Bend, Oregon 97703. Thank you for hearing testimony on these applications tonight. Central Oregon Land Watch is opposed to these applications. We have handed staff a copy of our written testimony. It includes some extensive attachments. I only have one copy of those attachments that staff has. I do have additional copies of our comment letter, if anyone in the room would like one, including yourself.
I'll take a copy of that. And I do review the entire record, but that might be great for me to read along as you present. Thank you. I appreciate it.
If you have one, I'll take it. Sure.
Also handing one to staff who has requested one.
Thank you, sir.
Okay, so this application seeks a plan amendment and zone change, and it's Land Watch's position that two major flaws are that it does not comply with statewide planning goals 3 and 14. This property is rural agricultural land. It's far removed from any urban growth boundary where new industrial urban uses are prohibited. There are also a few provisions of the Deschutes County Code that we've highlighted in our letter that we believe this application does not comply with as well. I guess right off the bat, since the applicant requested an extended open record period, we also include in our written comments a request for a 14-day open record period. I'll stick by that. I think 14 days would be sufficient. But in one sense, I'm glad to hear that the applicant has also requested that extended open record period. It's a pretty complicated application with a lot of detail, a lot of issues, as the staff report outlines as well. Starting with Goal 3, this property is agricultural land as defined by state law in Goal 3 in Oregon Administrative Rules 660-033-0020 subpart 1A and in Deschutes County's code at section 18.040030. The property is predominantly land classified by the U.S. Natural Resources Conservation Service as Class 3 when irrigated and Class 6 when unirrigated. And again, that makes this land agricultural as a matter of law under that first prong of the agricultural lands definition. Two of the tax lots on this property have irrigated soils as well. There's evidence in the applicant's application materials of CUID water rights. And because of that, this property can be considered for purposes of its agricultural land status as irrigated. So it is predominantly Class 3 because it is both within the boundaries of Central Oregon Irrigation District and actually has water rights pertinent. We've included as an attachment copies of the NRCS soil survey for the Upper Deschutes River area, that's Exhibit 1, and also a soils map of the subject property that includes a legend and the land capability classifications, both for unirrigated and irrigated of the subject property. These conclusively show that this land is predominantly, meaning more than 50% of its area, Class 3 when irrigated, and Class 6 without irrigation. Now, the applicant has included a soil study report in its application materials. It's called an Order 1 survey. That's how the NRCS classifies this type of additional information. But that survey in no way nullifies the official NRCS soil capability classifications for the subject property. This additional soils information in state statute at ORS 215-211 does not otherwise affect the process by which a county determines whether land qualifies as agricultural land. The NRCS's own soil survey handbook states that Order 1 soil surveys and site-specific data collected are supplements to the official soil survey, but they do not replace or change the official soil survey. So this is additional information about the soils of the subject property. It could be relevant towards other prongs of the agricultural lands definition. For instance, identifying land in other soil classes that, while it perhaps is not classified as 1 through 6, is still suitable for farm use. But this additional soils information cannot nullify or make void the official NRCS soil capability classifications, which are used as a matter of law to define agricultural land. Aside from its soils, again, going to the other prongs of the agricultural lands definition, this property is suitable for a variety of farm uses, including grazing. It's a common practice in Central Oregon to rotate livestock between pastures, whether or not they have water rights or not. And nothing prevents these 19 acres from being used in a similar way as seasonal rangeland. I've also included in our attachments to this, our comment letter, a joint letter from the Oregon Department of Land Conservation and Development, Oregon Department of Agriculture, and Oregon Department of Fish and Wildlife that was recently submitted on a similar application to Deschutes County, also seeking a non-resourced lands plan amendment and zone change to find that land that is currently zoned for exclusive farm use and designated as agricultural should not be protected by Goal 3. I include that letter here because it's really the same issue as whether land that is predominantly Class 1 through 6 as rated by the NRCS is agricultural land. And the state agencies in that letter describe the many ways in which land of even soils not Class 1 through 6, perhaps Class 7 and 8, can still be put to farm use, and how Goal 3's protections of agricultural land are not limited to Class 1 through 6. In any event, and this is important for this application, this is where it differs from the application that the 3 state agencies recently responded to. This property has both been historically and is currently, we believe, engaged in farm use, proving its suitability for farm use. There are aerial photos in the application materials at the applicant's Exhibit 1, pages 1 to 2, that clearly show irrigated crops being grown on tax lots 301 and 305 in the past. That's the site of those CUID water rights that exist on this property, and it's clear by the aerial photos that that land has been irrigated and used to grow crops. And even if the applicant states that those water rights have been leased for in-stream use, so they're not being put to irrigation on the subject property, but for the last about 5 years, it sounds like, have been leased back to the Deschutes River and not put to irrigation. The application also describes that currently this property is used for farm and other equipment service and storage facilities and related outbuildings. That's at application page 4. State statute at ORS 215-203 subpart 2 includes the on-site maintenance of equipment and facilities used in farm activities as a farm use under state law. So it sounds to Landwatch like the activities this property is currently being used for, as described by the applicant, equipment, service, and storage facilities for farm equipment, is currently an agricultural use of this property. So it's clear for multiple reasons that this is agricultural land, and that Goal 3 would be this application is not in compliance with Goal 3. Another issue that staff has also highlighted is Goal 14. This application proposes allowing what we believe are urban uses on rural land outside of an urban growth boundary, which would violate Goal 14. Staff mentioned the Assetti case, which has explored these issues extensively over the years through its various stages. Something that has an issue that has been argued in that case are the Schaefer factors, how LUBA has articulated those to explore whether one specific use is urban or rural. Here, there's not one single use that is being proposed. Rather, this is a zone change to rural industrial for this property. The rural industrial zone allows a wide variety of industrial uses that, if this zone change were granted, could be applied for, whether outright or conditionally at any point in the future. But this application fails to analyze whether those many allowed uses in the rural industrial zone would be urban or rural under those Schaefer factors. Now, as an alternative, we heard from the applicant that they also seek an irrevocably committed exception to Goal 14. OAR 660-004-0028 subpart 1 requires that a local government may only adopt an exception to a goal when the land is irrevocably committed to uses not allowed by an applicable planning goal because those uses are impracticable. Considering that rule, a big hole in this goal exception argument goes back to Goal 3 and how this property is suitable for agricultural uses. Agricultural uses are not impracticable on this property. Another part of the state's goal exception framework at OAR 660-004-0028, Part 2, subparts B through C, looks at the surrounding area, what they call the exception area and adjacent lands, and requires that the relationship between the requested goal exception property and those adjacent lands in the exception area also supports an irrevocably committed goal exception. Here, and I believe the staff report has information in detail kind of outlining the uses on the adjacent lands. There's a lot of agricultural use in this area. So kind of going back to my previous point about how agricultural use is practicable on this property, there are other provisions in state law that look outside of the bounds of the subject property to see if this whole area itself is actually irrevocably committed to uses not allowed by the goal. Finally, there are specific rules in the OARs about irrevocably committed exceptions for industrial uses. I'm referencing OAR 660-014-0030 that point to the difference between urban and rural uses, so kind of getting back to those Schaefer factors. And it's Landwatch's position that this property is not irrevocably committed to urban uses. And I think we've heard a bit of an admission from the applicant tonight that even if there were some non-conforming uses that were urban in nature in the past, that they have not operated continuously. So this it's a good transition to my next point, looking at a provision of the county code at DCC 18.120010 non-conforming uses. That code provision states that no nonconforming use or structure may be resumed after a one-year period of interruption or abandonment unless the resumed use conforms with the provisions of DCC Title 18 in effect at the time of the proposed resumption. In the application materials, it's repeatedly asserted that the nonconforming uses have operated continuously since the 1970s, and that point is used to justify several of the approval criteria. Now, based on what we've heard from the applicant tonight, I'm no longer sure quite exactly how this code provision applies, but I guess for tonight, I'll leave it at that the application doesn't include any evidence of how continuous those nonconforming uses have been, and that we concur with the staff report that evidence would be required to support the application's request for an irrevocably committed goal exception. The last point I'd like to make tonight is on Deschutes County Code 18.136020, which are the county's rezoning standards. The main text to that code provision states that the applicant for a quasi-judicial rezoning must establish that the public interest is best served by rezoning the property. This application primarily appears to seek the landowner's private interest by increasing the development potential of the property to allow an expanded number of uses. This application would not, however, serve the public interest, which would in fact be harmed by the removal of land from the county's agricultural land base, an unquantified amount of increased noise, traffic, pollution in a rural area that could come with rezoning to rural industrial, and public safety risks imposed by allowing industrial uses, and again, that concomitant traffic and pollution along both an open waterway, the CYD Canal, and a state highway. Moving down to subpart D of this code provision also requires that there's been a change in circumstances since the property was last zoned, or that a mistake was made in the zoning of the property in question. In the application materials, it states that the current uses on the property have been in operation for the majority of the past 40 years, which would point to no change in circumstance. And, you know, again, this makes me think of what we heard tonight, that apparently those statements in the application are wrong, and these non-conforming uses have not operated continuously. But I'd also like to point out that there has not been a mistake made in the zoning of the property. And this brings me back to goal 3, how I started this evening's comments. I've included as attachments to our written testimony tonight some materials from past attempts by the county to look at whether there are mistakes in its designation of agricultural lands and EFU zoning throughout the county. The first exhibit, this is our Exhibit 5, is a memo from Deschutes County's Community Development Department from January 5th, 2015, that includes notes from a conversation that staff had with the then planning director, John Anderson, who was a senior planner and then became the Community Development Department director when the county first developed its comprehensive plan and applied its agricultural land designations and the EFU zoning. And in that, in those notes, John Anderson states that there were no mistakes made when lands were originally zoned back in 1978. More recently, in the same era in 2015, when Deschutes County was again contemplating legislative amendments to its agricultural land designations and whether any mistakes were made, DLCD also weighed in and stated that it was unable to determine the nature and scope of any mapping errors in the agricultural land designations in the county. So, I bring this up now in the context of the county's rezoning standards, which require a mistake made in the zoning of the property in question. It has water rights. It's been farmed in the past. Its soils do qualify it under that first prong of the state's ag land definition as agricultural land, and there has been no mistake made in the zoning of the property. I will end it there. And just reiterating that because of these reasons, we request that this application be denied. And thank you for the time this evening. And if you have any questions for me, I'd be happy to try to answer.
Okay. Thank you, Mr. Isbell. Am I pronouncing that
Yes,
correctly? Okay, great. I do have a question for both you and for the applicant's attorney on rebuttal. And if you can't address it on the fly, on the spot tonight, that is something that I'd like some direction on when the record is left open. Assuming that a Goal 14 exception is required, does the loss of non-conforming use status take away the opportunity to argue that that an irrevocably committed goal exception applies? So in other words, if the use has not been continuous, can an applicant still nonetheless establish the irrevocably committed Goal 14 exception? And again, that's assuming that I would find that a Goal 14 exception is required. And similar question for the change in circumstances. If you're losing, or if that use has ceased, does that mean that a change of circumstances goes away? And again, I'm noting that there are two ways that this can be resolved, either a change of circumstances or a mistake is made in the zoning of the property. And I very much appreciate the detail that you went into in your letter here, and just kind of laying it 1, 2, 3, 4, 5 through the applicable standards. So what I'm looking for is more direction on the historic use, the cessation of that historic use, and how that factors into a potential Goal 14 exception and/or an argument regarding change in circumstance. I don't know off the top of my head if there's any LUBA case law or Oregon Court of Appeals case law on that. I'd be curious if there is. So I'm kind of putting it to both you and the applicant's attorney to see if you can provide some direction in post-hearing open record periods.
Thanks for those questions, Hearings Officer Marshall. I do believe there are provisions in the OARs that require continuity of non-conforming uses well, I shouldn't say non-conforming uses, that require continuity of that irrevocably committed use of a property. I don't have citations off the top of my head right now, but I will attempt to answer those questions during the open record period.
Okay, thank you very much.
Thank you.
All right. Is there anyone else present that wishes to testify in opposition to the application?
I don't see any hands.
Okay. Anyone present in person or online that wishes to testify in a neutral manner concerning the application?
I don't see any.
All right. Fantastic. Okay, since we've been moving along fairly quickly, unless there's a request from the applicant to take a quick break before rebuttal, I will ask that we just continue on. Are you okay?
I don't know. I'm apparently broke the system, but yes, I'd be happy to provide rebuttal at this point in time. I wasn't planning on it, but I just have to go through a couple of things. First, the applicant clearly disagrees with Central Oregon Land Watch's analysis under Goal 3, as well as the availability to supplement an NCRS study. The law clearly allows a site-specific analysis, which is what we have provided. That is, in our opinion, a piece of settled law that Central Oregon Land Watch is attempting to relitigate in this application and, quite frankly, many others. My guess is that by the time this goes before the Board of County Commissioners, as it's required to do, or before LUBA, that law, that this will be settled yet again in the favor of our analysis. So I want to point that out. On the question of water, this is one that, quite frankly, I personally struggle with because you've kind of got folks speaking out of both sides of their mouth. On one hand, you have all of this concern about drought, about using water for actual farms and for saving that. And you have articles like the Bend Bulletin today about how bad the drought's getting. And then on the other hand, you have Landwatch also in the same breath commenting on water rights and that we should apply that water to non-productive quote-unquote agricultural land that doesn't meet the definition of agricultural land under the law. And so I just have to say I struggle with that personally because I'm not quite sure what to do with it. Either you're evil because you use water, or you're evil because you don't want to use water for something that's non-productive. So I just throw that out there because I personally struggle with it, and I think it's something that maybe folks who are making comments about water should think about. Certainly, we'll be submitting a bunch of information that Landwatch itself has published on the issue of water. Secondly, with regards to the tri-agency letter that Mr. Isbell decided to drop in the letter, the conclusions of that letter are pretty clear. They looked at that particular subject property and not at this one. And so anything that they say in that letter, which is pretty cursory, they don't make arguments under the law for the most part. They say things like, having observed the subject property, we believe that it might be suitable for something X. So I would just say that letter really doesn't have an application here. And we're talking about something that's less than 20 acres of size in this particular case, that has 3 separate lots that have been used in 3 separate ways, potentially. On the question of ag use in the area, I'm not quite sure what Mr. Isbell was referring to. We don't see the same definition exactly in the statute. Seems like he's articulating that the storage of farm equipment and use of farm equipment is an agricultural use, but the county's code and state law doesn't really back that up. He's kind of splicing together the definition of agriculture and farm use. And to the extent he's arguing that the applicant could move forward with a diesel repair shop or a farm equipment shop and repair area, that would seem to conflict with the county code as well as state law on the matter. So I'm just kind of confused on what to do with that one. I guess it's something to be addressed by both parties during the open record period. With regards to a non-conforming use, let's be clear here, there's nothing in the rules that require a non-conforming use in order to seek an irrevocably committed exception. If there were, it would say that. It would say you have to have a non-conforming use in order to be irrevocably committed. And it doesn't require that. It's whether or not the property has been used in a manner that is inconsistent in all reality, and I'm obviously trying to shortcut this a little bit in terms of how I'm talking about it, but it's whether or not the use has historically been made of the property that would take it out of what it was zoned for. Okay, and so in this case, our discussion in the application was showing that for the entire pendency of Deschutes County's land use regulations, it has been used for something else besides ag land, or something else besides a traditional, under the state law now, farm use, which is typically a diesel mechanic shop and things of those natures. So that's why it's irrevocably committed. I mean, there are some physical aspects of this particular property that make it impractical also, but we're not going to get into those today. It's not necessary in talking about this, but I think it's important to note that he's conflating agricultural use with farm use, as well as what's actually required under that exception if it were necessary. And again, the law is very clear here, in our opinion. An exception is not required. We are asking for one because we also think this particular property meets it. But Deschutes County has a adopted zoning district called rural industrial, and we have the benefit of being able to rely upon that as a rural use. And the uses that are permitted in that are the uses that the applicant's seeking. We're not seeking an urban use. We are seeking something that has already been determined by the Board of County Commissioners and acknowledged by the state as being a rural use. And so that's kind of the end of that particular discussion. It's a rural use. If Landwatch wants to change the zone and remove a bunch of uses out of it, they can attempt to do so. But right now we have an RI district, and we can rely upon those uses. I think I'm going to leave it there unless you have any other specific questions for me. I missed the first part of the question, although I think I hit it about the non-conforming use status. There was a second question, but I'm not seeing it in my notes particularly well. If you want to articulate it again, I'm happy to try to answer at least my opinion on it as it stands today.
Oh, thank you. And yeah, so the second question was concerning DCC 18-136-020 sub D, where you have to show there's been a change in circumstances since the property was last zoned or a mistake was made. And I said, if we're only looking at that first prong, change in circumstances, I guess I'm looking for a little bit more on that, like how permanent is that change of circumstances? Is it even relevant if the change was there, but then the use went away? Again, I'm just kind of trying to cover the waterfront on possible ways to look at this. And I really appreciate both the attorneys that will be educating me.
Sure. The only caveat or the only other thing I'd say on that is a mistake was made. Could certainly be the fact that the NRCS took a 30,000 square, elevation look at the property, and we're providing a site specific. I'd also mention that, and I think we put this in our application, but we have a past zoning map where a portion of this property was not zoned EFU and actually provided for some commercial use, if I remember. But I would say don't quote me on that. But we do know that the map at one point in time was different than it was, and we weren't able to piece it together. So I don't recall. I'm just going to be brutally honest here. I do not recall exactly why that was or whether or not we put it in our application, but we do have old maps that do not show consistent zoning on this property. So we'll certainly track that down and provide that if they're not already in there. And if they are, then we will highlight it as best we can. That's all I got. I appreciate your time.
Yes, and thank you very much. Okay, so if no one else is wishing, well, I guess it's rebuttal time, so there is no other rebuttal. Unless you wanted a traffic engineer to, nope, oh yeah, we didn't really hear anything on traffic. Okay, so at this time, I will turn it back over to staff.
And I do not have any other closing comments if you wanted to go into open record discussion at this point.
Okay. All right. Thank you, Mr. Rawlings. Okay. So Mr. Katsaroff and Mr. Boy, I'm just so bad with names. Esbel. Thank you. Have both requested that the record be left open. I took down notes while Mr. Katsaroff was presenting, and he said, 28 days with a caveat that they may seek an additional extension. I can state that I would really not prefer that we have like multiple, like we go through it and then we do go through it again. So I would ask at this time if, and typically, again, the typical open record period is a 777, and it sounds like you were looking for maybe 1477. So please let me know if that's correct. But if you're concerned that the 28 days may not be enough time, then I would suggest we perhaps talk about maybe a 21-day open record first round. But
we were actually thinking a 28-day open round, and then
Okay.
7-day rebuttal, and then
Oh.
7-day
Okay.
legal argument.
Yes,
With
okay.
And the hope was potentially come back maybe in 21 days with a request to say, hey, let's do an extended open record for everybody, period. But
okay.
that's what we were thinking, and that would give folks an entire week to know that the applicant at least would request an extension. Not that necessarily would be granted, but hopefully that would allow us to have some time and maybe get either an order or a communication from the hearings officer whether she agreed or did not agree to an additional open record extension. That was the thought. I also do want to point out that the Assetti case on remand is going before the Board of County Commissioners on May 18th to the extent that's relevant or maybe relevant. And so we were thinking we may want to see how that starts to shake out at that hearing, but certainly our case needs to move forward in the way that the hearings officer determines.
Okay. I do appreciate that. All right, so I'm going to try to craft something here with, and I always do err on the side of allowing more time, more testimony. Again, we don't have a a deadline on the county side to reach a decision on these types of applications, so that's a plus. So if I was to look at my calendar and count out 4 weeks, which is 28 days to the 24th for the first round, I will orally require that if the applicant or any other person wishes more time than that initial 28 days, that a request must be made to the planner no later than 4 p.m. on May 17, Tuesday, May 17. Otherwise, you've lost that opportunity. It's a raise it or waive it. So with that in mind, and but let's just assume that there will not be such a request, the initial open record period for anyone to submit any evidence will conclude at 4 p.m. on 5/24, and I'll have Mr. Rollins go over how to submit, where to submit, and making sure that you don't miss the deadline, because that does happen. And so then rebuttal, so this is only rebuttal evidence to anything submitted by the 24th, if that's our hard and fast, will be May 31. That is the day after Memorial Day. Just kind of FYI, plan accordingly. And then final argument for the applicant only, the deadline for that would be Tuesday, June 7th. And I would like to ask Mr. Rawlings to go over how and when to comply with these deadlines.
Thank you, Hearings Officer Marshall. I'm going to share my screen really quick again. For the open record period, please keep in mind that all submittals should be addressed to me. For email submittals, you can use my email. It's on the screen. It's tarek.rawlings@deschutes.org. Email submittals which exceed 20 pages include any color documents or include any documents which must be printed larger than 8.5 by 11-inch paper must be submitted as a hard copy. The county does not retrieve information from a website link or personal cloud storage device. It is your responsibility to submit all evidence and testimony you want the hearings officer to consider. Any electronic submittals must be received by the county's server by 4 p.m. Please do not wait until the last minute to submit your evidence and testimony. Sometimes if you send it at 3:58, we receive it after 4, and that is technically outside of that open record period. So please just try to get them in early if you're able to. And then what we had just spoken about was, is the 28, 7, and 7 open record period. These are the dates that Hearings Officer Marshall had just gone over for. This is the general dates that apply to everybody, but I'll just, and Mr. Katzroff was just online then, but I'll just kind of reiterate the extension of the open record date is exclusive to the applicant, and that is May
21.
May 21, thank you. So that would be really helpful if we could just get that extension request in as soon as you're able to from the applicant side. But for new evidence and testimony, that 28-day period will end at 4 p.m. on Tuesday, May 24th. The following 7-day rebuttal period will end on Tuesday, May 31st at 4 p.m. And the final argument, which is the applicant's final legal argument period, that 7-day period ends on Tuesday, June 7th at 4 p.m. So please keep that 4 p.m. Cutoff time in mind. And here's my contact information if anybody does need that, just as a last minute. But that's all the information I had for you this evening.
Okay. All right, that concludes the public hearing. I appreciate everyone's time, and we will go ahead and close this open time period.